and then we just proceed. It's just fair to do that. But other than that, the chair is already on the floor. He can proceed. But we agree that the order paper will be reflected, will be amended to reflect that. Mr. Speaker, I beg to submit. Thank you. On the floor, he can proceed. But we agree that
thank you, Honorable.
the order paper will be reflected, will be amended to reflect that. Mr. Speaker, I beg
Honorable
to
member,
submit. Thank you.
I think that is maybe a little omission that it should have been the chairperson to present. Should have been a separate one, but it is there in the standing orders that what is doing is quite perfectly right in terms of procedure. So, Honorable Chair, can you proceed?
Thank you, Speaker, for your guidance. Through in terms of 22.0, object of the bill seeks to amend the East Africa Community Competition Act 2006 to streamline the provisions of measures with the international practice on the competition, to confer legal personality on the authority, to empower the authority to impose and correct financial penalties, and provide for related matters. Specifically, the bill seeks to amend the East Africa Community Competition Act 2A and brought the competition authority with legal penalty to enable it to discharge its functions as a legal entity of the community. B, remove the requirement for the authority to operate on ad hoc basis for the initial and the transitional period of not more than 5 years, which is provided for by Section 37, Sub 2 of the Act. C, empower the Council of Ministers to determine and prescribe the threshold for the measures that need to be notified to the authority in order to concentrate the resources of the authority on measures that have an impact on the community. D, provide for the authority to have sole jurisdiction in respect of matters of cross-border effect within the community. E, empower the authority to impose and correct financial penalties which are necessary in implementing and enforcing competition. 3, methodology. 1, during the consideration of the bill, the committee A, reviewed the East Africa Community Competition Act 2006, B, reviewed the treaty and the protocols of the establishment of the East Africa Community Custom Union and the Common Market. C, examined national, regional, and international legal instruments on the policy on the competition. 2, the committee interact with the following: A, chairperson, council of minister and his technical team. B, the commissioners and the registrar of the EAC Competition Authority. C, stakeholders. Roman 1, the East Africa Law Society. Roman 2, South Sudan National Chamber of Commerce, Industry and Agriculture. Roman 3, Rwanda Association of Manufacturers. Roman 4, Federal Chamber of Commerce and Industry, Burundi. 5, Roman 5, East Africa Trade Network, which comprises of the Southern and East Africa Trade Information and Negotiation Institute. 16, Uganda. Haki Madini, Tanzania, the East Africa Sub-Region Support Initiative for Advancement of Women, EAC, and the Rose Luxembourg Foundation, East Africa. 3, the committee also received a comment and a memoranda on the bill from Roman 1, the United Republic of Tanzania. 2, the Republic of Kenya. Roman 3, the Republic of Burundi. 4, the Republic of Rwanda. 5, the East Africa Business Council. 6, Africa Center for Competition and Consumer Protection and Intellectual Property Policy. 7, East Africa Trade Network, which comprise of the Southern and East Africa Trade Information and Negotiation Institute. Uganda. Haki Madini, Tanzania, the East Africa Sub-Region Support Initiative for the Advancement of Women, and the Rose Luxembourg Foundation, East Africa. 8, Kenya Association of Manufacturers. However, this to note that the Republic of Uganda and the Republic of South Sudan did not submit in their comment. 4, findings and observations. The committee made the following observation. Roman 1, A dynamic competitive environment supported by the effective competition policy and law is an essential element of successful market economy. Many developing countries that have undertaken market-based reform have recognized the need to have a law to safeguard competition. 2, the benefits that flow from competition are increased economic efficiency, innovation, and the consumer welfare. However, competition law is a relatively new area for most developing countries. The Competition Act is a complex economy law, and its enforcement require a highly professional competition authority. 3, not all partner states have a competition authority. It is only in Kenya, Tanzania, and Rwanda where there are functioning competition authorities. This despite the Council directive of partner states to establish competition authorities. EAC CM 35 Directives 06. 4, there are competition laws in Burundi, Kenya, Rwanda, and Tanzania. However, Uganda merely has a draft bill and there is no law or bill in South Sudan. 5, the absence of competition laws and authority in some partner states makes the implementation of the EAC Competition Act 2006 difficult, since the Act provides for cooperation between the EAC Competition Authority and the Competition Authority of the partner states. 6, the amendment will enable the authority to perform its functions better as a legal entity. This will be a big enabler to ensuring that the authority is able to deal with competition matters in the community and also the ability to enforce its decisions. The creation of legal entity will also insulate the authority from national interests. 7, Part 4 of the EAC Competition Act 2006 provide for the both mergers and acquisitions. Whereas the bill proposed to use a merger to refer to both acquisitions and the mergers, the two are related but can be separated, and there is no valid addition or benefit in referring the acquisition as mergers. Since there is no mischief or confusion created by referring to mergers and acquisition as provided for in Part 4 of the Act, it is not necessary to remove the definition of mergers from the Act. 8, the qualifications for the commissioners and the registrar of the authority are too restrictive. The Act only provides for persons to identified from holders of advanced degrees in trade or competition with at least 10 years experience. There is a need to open up the field to include business, law, and the commerce, and as well as reduce the number of years of experience, especially since there are no 3 partner states with functioning competition sector and authority. 9, Section 13. 4, provide for the council to approve a merger or acquisition which has been rejected by the competition authority for being anti-competitive if the council is satisfied that the merger fulfills an overriding public interest. The aspect of overriding public interest should be part of the criteria that should be taken into account by the competition authority at the time of considering the approval of the merger, and should not be left to the council to determine after the competition authority has subjected the proposed merger to the criteria specified in Section 13(2) of the Act. Indeed, the practice in COMESA, South Africa, and which is also provided for in the competition laws of Kenya, Tanzania, Rwanda, and Burundi, and the draft bill in Uganda is for the competition authority to also examine the proposed merger, taking into account the public interest. This is to ensure that the examination of the merger is done by the competition expert, taking into account all the considerations. 10. According to Section 38(3), the commissioner have a tenure of 4 years. This is different from the board of some of the other institutions of the community, like Civil Aviation Safety and Security Oversight Agency, CASOA, which is 3 years. Statistics Bureau, 3 years. East Africa Science and Technology Commission, EASTECO, 3 years. East Africa Health Research Commission, EHRC, 3 years. There is a need for the Council to rationalize and streamline the tenure of all the institutions of the community. 11. Section 47(1) of the Act provides for the authority to make and submit to the Council an annual report. Section 47(2) requires the Council to first publish the report in the Gazette before it is tabled in the Assembly. This procedure is different from what is provided for in relation to other institutions like Civil Aviation Safety and Security Oversight Agency, the Monetary Institute, and the Statistics Bureau, where the reports are either submitted as part of the annual report of the community or submitted in respect of a specific institution before or without being gazetted, so that they can consider by the Assembly in accordance with Article 49(2)(c) of the treaty, which require the Assembly to consider annual report on the activities of the community and other reports submitted to it by the Council. 12. Considering that some of the partner states are also members of the region blocks, such as COMESA and SADC, the ability to set threshold will support in the cross-referral of matters, both cross-border and the regional, that's helping in accelerating investment in the region. Since its enactment in 2006, the East Africa Community Competition Act has been amended once by the Assembly. 14. Globally, mergers and acquisitions are considered one of the same in relation to competition matters, and therefore, the amendment to the Act will not only create harmony, but also help create certainty within the business community and also predictability in the regard to the application of the law in the relation to the direct foreign investment to the community. 15. Regulation 3 of the ESC Competition Regulation 2010 provide that the notification referred to under sub-regulation 1 should submit in form ESCA 1 in the schedule and shall be accompanied by the prescribed fee to be determined by the authority. This is a substantive power of the authority which should be anchored in the Act and not regulation. The filing fees are paid in most jurisdictions, which is at the time of notification of mergers or acquisition to the competition authority. The rationale of paying the filing fees is to assist in merger and acquisition review activity, including investigation and analysis. The fees to be charged are linked to threshold turnover that provide for notifiable mergers and acquisition, which are already in the Amendment Bill 2020. Hence, in the issue of prescribing fees is not inserted in the bill, it will create uncertainty. 16. Jurisdiction with competitions laws within the region provide for charging fees under their respective instruments. In the Republic of Kenya, fees are provided for under Section 78, sub 3 of the Competition Act of Kenya, number 12 of 2020. In the United Republic of Tanzania, under Section 78, Section 2 of the Fair Competition Act 2003, Republic of Rwanda, and Article 17 of Law number 36/2012 of 21/9/2012, and the Common Market for Eastern and Southern Africa, COMESA, under Article 24, sub-Article 3 of the COMESA Competition Regulation 2005. 17. The committee expresses with great concern that the delayed conclusion of regulations which have hampered the smooth operationalization of key registration and institution of the community. The significance of favorable regulation in furtherance of ESC integration agenda cannot be overemphasized. 18, the bill is anchored on the provision of the treaty for the establishment of East Africa Community and the protocols of the Customer Union and the Common Market as follows. A, according to Article 75 of the Treaty for the establishment of the East Africa Community, partner states undertook the establishment of a Customer Union details of which would be included in the Customer Union Protocol, which came into force in 2004. Among others, Article 21 of the protocols provide that the partner states shall prohibit any practice that adversely affects free trade, including agreement, undertaking, or concerted practice which has its objective or effect to prevention, restriction, or distortion of competition within the community. B, according to Article 33 of the protocol on the establishment of ESC common market, provide for prohibited business practice. Precisely, the article provides thus: the partner state shall prohibit any practice that adversely affects free trade. The provision of paragraph 1 shall apply in the case of 1, or agreement between undertakings, decision by association of undertakings, and the concerted practices which may affect trade between the partner state and which have as their objective or effect the prevention, restriction, or distortion of competition within the community. 2, concentration which create or strengthen a dominant position and as a result of which effective competition would be significantly impeded within the community or in a substantial part of the community, and any abuse by one or more undertaking of dominant position within the community or in a substantial part of the community. However, the provision of paragraph 1 shall not apply in the case of A, any agreement or category of agreement between undertakings, B, any decision by association of undertakings, or C, any concrete practice or category of concerted practices. 5, recommendations. The committee recommends that the Assembly, 1, adopt report of the Committee of the East Africa Community Competition Amendment Bill 2020, and 2, passes the East Africa Community Competition Amendment Bill 2020 together within the amendment proposed by the committee.
I would now want to open the debate, and now, honorable members, the debate is open on the report of the committee. So, can I have members who want to contribute to this bill or to this report? Yes. Yes, Honorable Gideon. Honorable Gideon, can you continue?
Thank you, Right Honorable Speaker. I rise to support the motion and would like to declare that I'm a member of this committee. This is a a report about the amendment of this very important bill of the East African Community Competition Authority. The authority is in place as established under Section 37 of the East African Community Competition Authority Act. But Right Honorable Speaker has mentioned in the report, the authority was lacking the legal entity so that it can be able to carry out its functions. One most important thing that I want to emphasize here, Right Honorable Speaker, is the fact that there is need to regulate our competition. Our young industries, our young businesses, our infant industries or so are likely to suffer, to be kind of constrained in operations by bigger companies who have obvious intention to monopolize the market in East Africa. This bill is very important in a sense that it provides an opportunity for both the infant companies or infant industries to grow, while they could be able to register themselves with the authority for fast tracking without charges. But also at the same time, Right Honorable Speaker, this bill, according to this report, also provides for the authority to be able to impose charges for filing the mergers and acquisition for companies that have the muscles and capability to be able to manipulate the market. Only for those companies that their impact can be realized in the market negatively are those that have got the possibility to be having charges imposed on them. This is good to regulate the market competition. East Africa can only realize its importance as a community that promotes trade and industry when competition is regulated. Right Honorable Speaker, there was a case in Kenya before. When we were in the colleges, somewhere in 2000, 2002, from 2000, 2001, 2002 there, we used to see a brand, Castle beer in Kenya. And along Thika Road, we used to see the beer factory. We used to enjoy a lot of that beer. But all of a sudden, it disappeared. We asked ourselves, where is Castle? Later on, we could only find that Castle is gone because a bigger giant in the region has also swallowed the same. So who were the victims? It was East African who were employed in the Castle beer industry. These are examples that we need to avoid, and they count to the importance of this kind of a bill, that we need to regulate the competition, and the authority should be clothed with all the necessary legal instruments to be able to carry out its activities perfectly. Right Honorable Speaker, let me draw your attention to page 6 of the report, number 15, that is saying initially the authority did not have the competence in terms of imposing subscribed charges on the acquisitions and mergers. They were only not hung into the main law. They were kind of placed in the subsidiary law, which is in the subsidiary regulations. So it is important that this is caught in the main law so that the authority would be able to do its work accordingly as anchored on the law. Right, Honorable Speaker, as I declared already that I'm a member of this committee, I support the report and urge my colleagues to be able to enable the competition authority to have the muscles it requires to be able to carry out its activities in the region and in our community. Thank you. I submit, Right Honorable Speaker.
Yes, honorable members. Yes, okay. John Claude. John Claude. Yeah, John Claude, can you proceed? Honorable members, you appear to be a bit dull. I don't know what is. How can I wake you up so that you, you become a little, you're awake? Okay. Okay, Jean Claude, can you?
Thank you, Mr. Speaker.
Thank you.
I think it may be also because this particular bill has some technical part of it that members who are not members of this committee on communication, trade, and investment need some introduction for them to be familiarized by this particular bill. Honorable Speaker, I want to first declare that I'm a member of this committee of communication, trade, and investment, and I support the report, and also I support the bill to be read for the second time. My concern is one or two, but before I just want to confirm that competition is always important in trade, because where there is no competition, it is believed that there is no efficiency in the production. There is no, of course, where there is no competition, there is monopoly, and the monopoly has also some consequences on consumers, because monopolistic companies, sometimes they increase prices in order to maximize the profit at the expense of consumers. And these particular authorities, competition authorities, they are aimed to protect consumers from those bad behaviors or bad practices of monopolistic companies. And they are just to regulate companies, how they merge, they come together, and also how the companies acquire each other, how they buy, companies buy other companies, which we call acquisition, but also things related to concerted practices. Right Honorable Speaker, when we were discussing about this bill in the committee, we found there are two issues that raised so much our attention. First one is about the duration for this authority to approve or decline a proposal of a merger. It was proposed to be 120 days, meaning 4 months for a company, for particular companies, 1 or 2, which are willing to come together, and there might be many reasons for those companies to come together. There are sometimes failing companies or companies which are facing challenges because of the environment where they are operating in, especially small companies they may wish to come together in order to join hands so that they may be competitive on the market. So for that, those companies who are just failing to function and they are willing to come together in order to survive, if the proposal of these companies to come together is approved after 4 months. So in the committee, we found that as also a hindrance for those companies to survive. But the stakeholders we have been able to engage with, together with the registrar, they have been able to convince us about that this is the maximum possible duration of time that this merger can be, during which this merger can be approved. The second issue, which also raised our attention in the committee, was about companies which are willing to merge, but the merger is anticipated to be anti-competitive. But because that merger is overriding public interest, it can be allowed. So, so our concern was who is going to approve mergers which are overriding anti-competitive in nature but are overriding public interest. That it shows that we have competition laws in Burundi, Kenya, Rwanda, and Tanzania, but Uganda only has a bill, and Burundi and South Sudan doesn't have either a law or a bill of this nature. So it will be also a challenge for this authority to transact or its activities on its core mandate if we don't have also the same kind of authorities in all partner states. That is why I'm urging to the Council of Ministers to follow up on this matter so that the bill which is in Uganda, Republic of Uganda, also can be passed and become a bill, and also the authority to be established. The same for the South Sudan, the Republic of South Sudan. Right, Honorable Speaker, I beg I support this report, and I beg honorable members also to support this report and pass and also support this motion for this bill to be read for the second time. I thank you.
Honorable Pamela, Honorable Dongo, Honorable Dr. Daktari, and Kalinda, yes, Dr. Kalinda, and yeah, in that order. Who's standing? Oh, Honorable Usi. Honorable Usi. Yeah, something. Honorable Usi. Okay, thank you. Honorable Pamela.
Qualification.
There's nobody from this side. But anyway, it's okay. Clarification.
Yes.
Who wants clarification? Okay. Yeah. Continue.
Thank you, Mr. Speaker, for the opportunity to express myself. I seek clarification from the committee about the object of the bill. First of all, the main object is the bill seeks to amend the East African Community Competition Act 2006 to streamline the provisions on mergers with the international practice on competition. When I read through this report, I found that members were able to examine national, regional, and international legal instruments and the policy on competition. But I could not find anywhere these international legal instruments informing this assembly about what is going on their side, so that we can imitate them if we have to buy a leaf from them. So I would like maybe the chair of the committee or members, as they debate, to also clarify on this, because we are kind of buying leaves from international instruments, and I didn't see what transpired from their scrutiny of the documents at international level. Mr. Speaker, I seek clarification. Thank you.
Yeah. Thank you, Honorable Mukiza. That is a good one, but please raise it. I will give you an opportunity when you are debating to raise it, so that when the chair is replying, he will mention something about it. He will clarify about it. So let us just debate.
Mr. Speaker, I don't have intention to debate. That's why I just start clarification.
Yeah, but I will give you an opportunity to,
Mr. Speaker,
to explain.
can I give him?
No, please. Honorable Pamela, continue.
Thank you, Mr. Speaker, for giving me this opportunity also to put my contribution to this report. First, I would like to declare that I'm a member of this committee, and I stand to support the observations and the recommendations from the committee, from the report. Mr. Speaker, I just have only one serious concern about the bill which was submitted to us, and also which goes together with the recommendations which we provided during the assessment of this bill. Mr. Speaker, looking at the objective of this bill, you can see that it aims to enhance the welfare of the people of this community and many others. And among the major activities of this authority is to ensure that there is a safe and good environment for the people of this community, especially in transacting the business. Mr. Speaker, we all agree that there are different dynamic competitive environment for different activities which are undertaken by the people of this community. And most of them, they have been blocked by the so-called different policies which are coming from our partner states. From the EAC, we have something which is called the SQMT, which is the section under Secretariat who are dealing with the harmonization of standards. Now, looking at the process which is taking place in Secretariat, there are a lot of standards which are supposed to be harmonized so that they can provide the good environment for our people. But if this thing is not yet done, I don't think if this authority can perform its work, because talking about having the competitive environment, how do these two, for example, the two partners from one partner state to another compete, whilst we are not accepting one another products? We really need to emphasize first to strengthen or to implement the process of harmonizing the standards which we have first, so that we support this authority to perform its mandate. If we don't fast track the process of harmonizing the standards at the EAC, even this authority will not succeed. Mr. Speaker, I beg to submit.
Thank you, Honorable Pamela. Can I have Dr. Kalinda? Dr. Kalinda, then Honorable Dongo.
Thank you, Mr. Speaker, for giving me the floor to contribute to this report. I want, first of all, to thank the chair of the committee on trade and investment for a good presentation of the report. And so I thank the members of the committee for coming up with interesting output. Mr. Speaker, mine is a question. It's a question to the chair of the committee. Mr. Speaker, the report highlights that two member states of the East African community do not have an act to regulate competition on their territories. These are the Republic of Uganda and the Republic of South Sudan. And the same partner states did not submit their comments to the committee. Yet, these partner states have assented to the East African Community Competition Act 2006. Now, my question to the chair of the committee is to know how sure are we that once this August Assembly amends and passes this act, how are we sure that the two partner states are going to assent to this amendment? Honorable Speaker, I also want to know why this report does not have a recommendation to the Council of Ministers to urge the Republic of South Sudan and the Republic of Uganda to enact laws, to enact acts regulating competition on their territories. Mr. Speaker, I beg to submit and I thank you.
Thank you, Honorable Dr. Kalinda. I hope that will be answered later. Now, can I have Honorable Dongo?
Right Honorable Speaker, first I would like to thank Council for coming up with this amendment, and also to thank the chair of the committee that I belong for this report. Right Honorable Speaker, in political economy, is what they call the law of necessary conformity. The law of necessary conformity states that when productive forces change, then the superstructure of necessity has got to change in order to respond to the changes in the production and the productive forces. Right Honorable Speaker, superstructure are laws, are institutions, regulations that are put in place to govern those changes. It's therefore important that as we, as a community, embrace the processes that are ongoing in Uganda so that they begin to inform the discussions, the debates that are taking place in the Ugandan parliament, so that they can, if there are areas of contradiction, they can easily be amended to reflect our commitment as a country to the regional law. So, Right Honorable Speaker, I think that this is a law that should have been passed long time ago. Because already in our different partner states, we have had mergers, we have had acquisitions, and some of them have been part of the problem that we discussed yesterday. That some of the mergers, some of the acquisitions have actually ended up being conduits for illicit financial flows. Therefore, for us to have a strong institution like the Competition Authority should be able to, to regulate the conduct of such businesses, but also to do due diligence before companies either acquire or merge. We are seeing tendencies within the region where huge companies are coming and buying off. It's in the financial sector, and it's also in the telecom sector. And these are the key drivers of our economies. These are the big players in our different economies. So we need to stand up as an assembly and come out with a law that will protect the interests of East Africans. Right Honorable Speaker, I beg to move.
Honorable Bosi.
Thank you, Right Honorable Speaker. Let me declare that I'm raising to support the bill, but I have one concern which some of my colleagues have touched on, but I just want to point it out again. I am in support of this bill, but Right Honorable Speaker, when and also let me congratulate the CTI committee for amending this bill, obviously from Council of Ministers. So also let me congratulate Council of Ministers and Chair Council for amending this bill. Before I put my comment, one of my colleagues said that this laws is not in other partner states, but in regional legislation, the law we are making here, one of the aim is to unify other laws that are already existing in partner states. But when that law is missing, one of the reason why we are legislating in a regional level and our laws are they are superseding national laws, is to make law whereby that partner state, that law is lacking. So it is not a condition that a specific law must be existing in the partner state before we legislating. So right now, Mr. Speaker, I have one point which is starting from page 3, whereby the report says they have not received comments from Republic of Uganda and Republic of South Sudan. And on page 6, on the issue of fees, on comments number 15, is it comment or it's finding an observation, number 16 and 15 and 16, in regards to the prescribed fees to be determined by the authority. Right, Noble Speaker, even though this is a council bill, but the report should have explained what happened in other partner state fees, whether they have those fees. I realize now, according to Rombodong, they don't have this in Uganda, but whether South Sudan, Uganda, and Burundi, which have not been explained here, that they have those fees, because according to 16, the report explained jurisdiction with competition laws, which has providing charging fees, but they mention laws from only 3 partner states, which is Kenya, Tanzania, and Rwanda. Just for information, I know this is known, but just to remind, all the bill have to have uniformity, especially in terms of the fees. So I just wanted to know, hence this bill, even it existing, but the amendment must be receive assent from all 6 partner states. So I want to know on the issues of fees, was other partner state consulted? Because the fees seem to be left to partner state itself. Otherwise, the other 3 partner states, which it was stated in this report, have already provision of the charging fees. So I wanted to know from the mover, Chair Honorable Chris, when he come up, to tell us what happened, what was the agreement on regarding for charging fees for the Republic of Burundi, Republic of Uganda, and the Republic of South Sudan, because we need to have uniformity, especially on the issues of fees. Thank you, Right Honorable Speaker. Otherwise, I'm supporting this motion and I'm supporting this amendment of the bill. Thank you.
Thank you, Madam Musi. Honorable Mary, Honorable Abega, Honorable. Yes. You are not. You want to speak? Okay.
Yeah, Speaker, I'm here also.
Okay, Honorable Dut and Honorable Fatima. Okay, in that order. So, Honorable Mary, you are on the floor.
Thank you, Mr. Speaker. Mr. Speaker, I want to start by declaring that I'm a member of this committee and that I support the bill. And I want to take the opportunity to thank the Chair Council and the Council for bringing the amendment to this important bill. May I also take the opportunity to congratulate the countries, Kenya, Rwanda, and Tanzania, that already have the laws in place, which I believe protects the business environment and ensures regulation and fairness, and also protects the economy. Mr. Speaker, I note that if you look at page 4, findings and observations, number 3, actually 4. Number 4, when talking about countries that have not put in place laws to regulate competition, I would like to edit this sentence that says, however, Uganda merely has a draft bill. I think we'll do better by removing that merely, recognizing the effort that is ongoing. The country is in the process of legislating in favor of regulating competition. So it's my considered opinion that we note that however Uganda has a draft bill, Mr. Speaker, secondly, I also want to add my voice to those who think that there should be harmonization of the term of office across the institutions of the EAC. The commissioners are being given 4 years. But if you look at the other institutions, they all have 3 years. So my proposal is that we either increase and to 4 years, if that's what the council would prefer, and I believe they would have considered the reasons, or bring all of them to 3 years, in which case we give the commissioners also for this authority a period of 3 years. Mr. Speaker, I would like to bring the attention of the House to issue number 14 about fees. Actually, I think it's 15. And I remember bringing this issue at the committee level, and I would like to bring it back here. I believe that fees should be charged, most importantly to the big companies, businesses that wish to merge. And that's where the big monies are. Those are the guys where big fees should be collected, so that then it helps to raise money to fund some of the activities that are being done. In most countries, of course, money collected in this way goes to the revenue authority. Then under the Ministry of Finance, money is appropriated, it goes to the general fund of the economy. But this money is very helpful, and it should not go free of charge. My issue, though, is that the fees to be charged are linked to the threshold turnover that provide for the notification, merger, and acquisition. Right. But I still think that even the smaller guys, even the smaller companies, should pay something relative to their size. If the fees is to be charged according to the threshold turnover, let's not have those that are not paying anything and then those that are paying a lot. Let it be relative. Small guys pay, even if we fix a minimum fee, you can have a minimum fee for the smaller companies. Most of these companies are owned by nationals. The big companies, which then, according to the valuation of the threshold, would be the ones that will be paying bigger fees. But I believe that even the small nationals should pay. And cumulatively, even if they are charged a minimum fee, it makes sense in terms of collecting revenue for the country, but also getting all businesses to know that this is the practice. Once you apply to merge, there is a fee that is charged. Otherwise, Right Honorable Speaker, I want to thank the chair, my chair for the committee, for a report well presented, and I support it. I thank you.
Yeah, thank you, Honorable Mary Abega, Mheshimiwa.
Thank you, Right Honorable Speaker, to give me also the opportunity to make my contribution on this debate. First of all, I would like to congratulate the committee on trade, investment, and communication for the good job, and congratulate the chair for leading the committee to that good result. Right Honorable Speaker, I would like to note that since I was following the East African business, I saw that around 2015, I think we started to talk about the East African Competition Authority. And in the paper, it's good thing and good theory, but I do think that the issue is that since the idea to set up the East African Competition Authority, I trust that all partner states don't have enough willing to implement what is the content of like such of bill. And one can note that many stakeholders have limited knowledge on the role of competition policy in the community. That's why the implementation of the bill must be crucial. And beyond all, I think that the partner states, the stakeholders have to get enough willing, and take the source or in the principles, the fundamental principles of the community, which prescribes among mutual trust, political will, and sovereign equality. So for me, I think that debating on the contents, the bill is good, but we have to focus on the implementation. In the practice, what is happening? There are the partner states willing to work and in a fair trade, win-win, not some think that they are the strongest or they are the winners and as the losers. Otherwise, we'll be here maybe in 2 years commenting the same thing and not that we didn't go on, we just march on place. I submit, Chair. Mr. Right Honorable Speaker. Thank you.
Thank you, Mheshimiwa. Now, Honorable Umukiza Francois.
Thank you very much, Mr. Speaker. I take this opportunity to congratulate you upon your election, because I did the great opportunity yesterday. You were elected our Speaker to preside on this assembly transactions. And the report of the Committee of CTI we have here. At the beginning, I tended to not understand anything, but as I have been hearing from the previous speakers, I'm now getting something, and I found it important even because if we straight go to page 6, whereby Roman 13, we are reading the bill is anchored on the provisions of the treaty for the establishment of the East African Community and the protocols of the Customs Union and the Common Market as follows. The rest I need to read. This shows us that this bill is important because it's touching on the pillars of integration. Hence, so important. And also Roman 16, I'm reading some jurisdictions with the competitions laws within the region that are providing some articles in the Republic of Kenya, Republic of Tanzania, the Republic of Rwanda, etc. Though we are not having 6 partner states here quoted, it's very important to bring those missing on board, but not really rejecting this bill. Otherwise, we will miss an important thing. The questions I had at the beginning remains because if I see the main objectives or object of this bill was to streamline the provisions on mergers with the international practice on competitions. And my concern was to know about, for instance, some good practices of these international practices. What did you find as a committee about this, so that we can buy a leaf from them and then expedite this amendment as the House? But even before that, I think it is very important because we need harmony in this region and we need certainty within the business of this community. And also we need predictability in regard to the application of the law.
Mr. Speaker, information. Honorable Jean-Claude. Information. Yes.
Jean-Claude, you have some
information to give to Honorable Francois.
You accept the information?
Yeah, I just finished one sentence and then you can bring it. See?
Okay.
Yeah.
Continue.
Because the information
Continue.
may be also to be part of what I'm saying. One sentence
and you give him.
Okay. Yeah, because we have to really to bring harmony, as I was saying, and also predictability with regard to the application of the law in relation to direct foreign investment, and also this community to welcome, I may say, integration with the all partner states. I take the information because I'm sure it's related to the concern I have. Thank you.
Thank you, Mr. Speaker, and I also thank you, Honorable Francois, for allowing me to give you information. For about your concern on whether we have also consulted, as we mentioned that we consulted other international competition laws, and we borrowed a leaf from them, and it is mentioned on page 6. Page 6, Roman 16. You find that we consulted commercial laws, and especially about charging fees. I think that is that also addresses your concern on whether we borrowed a leaf from those international competition laws. We consulted them, and yeah, thank you.
Very much. My concern was about globally, because that one is kind of, they are closer blocks. It was about global. When we talk international, globally, it's the US, Europe, such kind of, global practices. Thank you.
We go to General Dut.
Thank you very much, Right Honorable Speaker, for giving me the chance. First of all, would one also to add my voice in thanking the Chair Council and the Chair of the committee for this important amendment, and then this is a good report. And also thank the members of the committee. I rise to support the report. Report capture a very important objective, which really equipped this important bill, which can allow it to carry out and discharge its work. About the issue of the other two member states, which have not yet joined in establishing this important institution, it will be an obligation because the other two assented to this, to the treaty. So it will be a matter of processing the establishment. I don't see any big deal here that the other two will object to establish and join the other member state in this important in the establishment of this important institution. The other point of my concern also, which I would want also to concur my colleague George Udongo, is in the recommendation. I would want also to concur with him and urge the council in this area of the implementation, because they would want also to encourage the other two member states we have not joined in to also establish this important institution, because all in all it addresses the need of this East African community. So finally, I support the report, and I would want, I urge my colleague that we pass this important report. Thank you.
Thank you, General. Now the last one, Honorable Fatma.
Thank you, Honorable Speaker, in allowing me to contribute to this motion of the report of the committee. Honorable Speaker, first I want to acknowledge the commitment of the committee, because if you look at the last page of the committee report, they all committed their signature to this report, which is a clear indication that they have confidence in the report, and the report reflects their views. Definitely, the report cannot capture everyone's views, but the principles and the main issues are captured. Congratulations, Chairman, for securing your members. Honorable Speaker, the report is very good, but I find sometimes a bit of not providing all information. Honorable Chair, Honorable Speaker, I really like the object of the bill, and the bill is very clear that it wants to strengthen the competition authority of East Africa, the East Africa Competition Authority, to function properly with all the powers within the law, if supported, so that they're able to discharge fully its function. Honorable Speaker, the way I read the report, the authority sometimes works on an ad hoc basis. Honorable Chair, the other thing I wanted to know from the chair is in many of our countries have laws, and I have seen the one of Kenya. I have interacted with it now. And the only country that has no substantive laws, or two countries, is the Republic of Uganda and the Republic of South Sudan. And of course, Uganda is on the way with a bill, which they have a draft bill. And but the Republic of South Sudan doesn't have. Honorable Speaker, when a country have their national laws, it really complements the East Africa community laws. So I think it's very necessary. It's not a requirement to have a law, but if a partner state has its national law, then it's able to complement and easily anchor the East Africa community laws with the national laws, because you have to work with the national competition authority of that particular partner state. So it's very necessary for partner states to have a law of their own. Honorable Speaker, I want to move you to Roman X, which is on page 5. According to the section, it says many of the East Africa communities, the commissioners have different tenure. Most of them are 4 years. This board is different from others. So I think harmonization and rationalizing and streamlining the tenure for all institutions is very critical for the council members to take up quickly. And it's very important they do it, could be within the term of this EALA 4. Honorable Speaker, one thing I expected the committee is if you go to page 6, they talk Roman X V1, which is number 16, X V1. They say many countries are charging fees. Their competition authorities, the law clearly spells out fees. Unfortunately, the committee didn't give us comparative situation of how much each partner state is charging. And I tried to read Kenyan's law of the competition authority, article 78, sub-article 3, and it doesn't clearly state how much they are charging. It says, number 3, the authority may make rules, because I have not interacted with the rule, prescribing filing fees and other fees to be paid by persons in connection with the procedure of the authority. Honorable Speaker, I think it will have been very useful for members to interact how much each partner state, especially the ones which have already existing laws like the Republic of Rwanda, the Republic of Kenya, the Republic of Burundi, and how much they are charging, so that we are familiar with what is happening, and how much that amount is very appropriate in terms of providing opportunities for all categories of actors or stakeholders to fairly compete. How much is it limiting, or is it inhibiting, or is it a moderate fee to charge? Honorable Speaker. Honorable Speaker, the other issue is the committee expresses with great concern the next one, X17, XV11, says conclusion of regulation which have hampered the smooth operationalization of key legislation and institutions of the community. I think it's unfortunate that we, as much as we are pushing for a law, even the minimum basic things like regulation is still not in place. So, Chair, I think we need to, and this, the council member who is representing the council members, as is not around, but I think the answer will capture, is to conclude these regulations, which is enabling to this thing, so that we have a smooth functioning of institutions, so that when you make a law and then the regulation is not in place, so you are not maximizing the benefits of the laws because of the absence of regulations and rules that will have been helping the work. Honorable Speaker, my last one is on the recommendations. I realize the committee has only 2 recommendations, and is to adopt the report, and the other one is to pass the East Africa Community Competition Bill 2020 with the amendment proposed by the committee. And I personally felt that could be the 3rd recommendation is to seek the intervention of council members or urge them, so that all the 6 partner states of East Africa Community are at the same page in terms of having a law, a domestic law, so that it doesn't hamper the smooth running of the East Africa Community Competition Authority once the bill is on. Honorable Speaker, when a partner state doesn't have a law, then it becomes a challenge to enforce or could be take advantage or maximize benefit that an East Africa Community law, because there is a lot of interconnectedness and interdependenciness of East Africa Community laws and the national laws at our partner state. Honorable Chair, thank you for allowing me to contribute.
Yeah, thank you, Honorable Patman. Now, Honorable members, I think we have exhausted the bill. We have discussed it, and I want to allow 2 members to conclude so that we can now go to the next step. And the 2 members are Honorable Oda and Honorable Musamali, in that order.
Thank you so much, Right Honorable Speaker. As I'm taking the floor for the first time since you were elected, let me say congratulations. And you know I'm your fan. So I was happy that you were elected. And the way you are conducting the business of the House is so good. Thank you, Right Honorable Speaker. Right Honorable Speaker, I want to first of all declare that I'm also a member of this committee, and want to thank the chair, the council, for bringing this amendment of this important bill. This is one of the important bills, especially when you consider the motto of this assembly, of this community that is private driven. And when the council, with the support of the secretariat, takes time to review the bills which has been passed some years back, of course, being informed by our private sector on where they are having some challenges, and the council taking a lead of analyzing and coming up with the recommendations to this assembly in amending the bill is something to recommend and to appreciate. Right Honorable Speaker, I want also to thank my chair, my able chair of this committee, one of the very important committee of this community. As I mentioned, the private sector should lead this community if we really want to achieve the objective of this community. I'm going to be brief, Right Honorable Chair, because I'm a member of this committee and I support this report. And it's a bit straightforward. The proposals by the council are quite right and straight to the point. So as other members also have discussed the importance of these amendments in order to fast track the implementation of socioeconomic improvement of this community. I just wanted to add my voice to my colleagues who really came back on the issue of implementation. Right Honorable Speaker, this assembly or this community, since it has been in place, has passed many important bills to be recommended. But it is disappointing sometimes to find that the resources which has been put in all this exercise to put the bills in place, when you go into monitoring the implementation and the outcome of these bills in our member states, and you find we still have a lot of NTBs. The bills are good, the amendments we are doing are good, but at the end of the day, you find that we still, in some areas, lag behind because of, as my brother, Honorable Kasamba, her soul rest in peace, used to tell this assembly that the mindset, the barrier which are caused by NTBs are really frustrating this community. So I just wanted to request the Council of Ministers to continue putting more efforts, making sure that all these bills are being implemented in our member states and put in place the mechanisms. We are with the CTC here. I always, when I stand up, especially on the issues of implementation, request to understand what are the mechanisms which are in place to monitor, because if we don't monitor what we are doing and report back, and come up with more strategies to make sure that the impact, the outcome of what we are doing at the community, then we'll be just wasting the little resources of this community. So I just wanted to say that the bill is good. I support the bill, but I continue to request all of us at different levels, the assembly, the council, by the support of the secretariat, to continue put in place mechanisms to do the monitoring, report back, so that at the end of the day, these benefits, we are waiting for our people, especially the private sector, which is going to drive the business of this community and for the betterment of the social economic aspects of our citizens is going to be achieved. So, Right Honorable Speaker, once again, I support the report, and I thank once again the Council for this important initiative and encourage them to continue monitoring other bills which needs amendment or new bills, and also to follow up on the other bills which are not yet assented to. I submit, Right Honorable Speaker.
Somali. Thank you. Honorable Order.
Honorable Speaker, Mr. Speaker, thank you for giving me this opportunity to make my contribution on this bill. I want to start by stating that I'm a member of CTI committee, and I made my submissions in the committee, but because of some of the submissions which were made by members here, I was propelled to make further contributions. And there was also a wake-up call from you, Honorable Speaker, when we were looking like about to start thinking while the eyes are not seeing very well. But Honorable Speaker, let me also take this opportunity to congratulate you upon assuming that very challenging seat. And your assumption of that seat made me to further believe that the power and authority come from God. Because as you are aware, you are my neighbor here, and you never had any intention to become a speaker. But Honorable Habib, all the way from that side, he nominated you. And you didn't shame your neighbor, you took up the appointment. Thank you, the nomination. to the bill, and very brief, Honorable Speaker, I support the report, and I request members also to support, to vote for this amendment, such that we have this law in place. Honorable Speaker, as you are aware, our community is best. Our integration is private sector led and people centered. And we have a slogan of one people, one destiny. But we have been having a challenge, Honorable Speaker. These are partner states which have come together to integrate in all spheres of life. But when you look at what my brother here, Honorable Pierre Clever Rakamvie, a beggar, he said, we have a problem. And he was requesting that when this law comes into place, we want political will from partner states. Now, we chose to come together. Why are we again pleading for political will? But I will just add to that. Honorable Pamela, she talked about the different standards that exist, that we need to harmonize these standards. and then the Honorable Odongo. And these are the reasons why I got up to speak. He says he brought us to the laws of conformity. Now, Honorable Speaker, I have an example that our partner states, I don't know personally up to now, I'm now a little bit puzzled why many of our governments, the 6 governments, chose to reestablish the East African community. Because here we are centered to the treaty and the various laws, the customs union protocols, the common market protocols, the monetary union protocol, and so on and so forth. Now, we are centered to these protocols, but the problem comes on implementation. So why I support this law is that partner states have been falsely claiming, excuse me, when products come from one partner state to another, and then they introduce the NTBs and other barriers, claiming there's a problem of standards, there's a problem on one thing or the other, they stop these products from entering a particular state, and they were claiming in terms of standards. So my view, why we thank the Council of Ministers for bringing this amendment, is that probably it will serve as a solution in one way or the other. My view is that if company A is operating in Uganda and the company B is operating in Kenya or Tanzania or any other partner state, they are all producing the same products. Because these are the reasons why the barriers come in. So if these 2 companies or 3 companies from the different partner states produce the same products, my view is that when this law comes into place of mergers and the acquisitions, these companies which are producing the same products will be able to merge and sell, because they will be more or less the same company. If it's a milk company in company B, I mean partner state B, a milk company in the partner state A. Now, instead of colluding with your government, and then you slap sanctions and barriers on company A from one partner state, you will be able to work together, acquire or merge for purpose of avoiding unnecessary competition, and then you sell and produce and sell in the community. So, Mr. Speaker, that is what I assume that at the end of the day we are going to achieve. Companies now, instead of creating cartels and colluding with governments to stop products from other partner states, they will be able now to work together such that we minimize unnecessary competition. Otherwise, Honorable Speaker, if we as East Africans, if we don't work together and avoid unnecessary barriers, we shall be swallowed. So because of that fear, Honorable Speaker, I support this bill. I support the report, and I thank the Council for sponsoring this amendment such that we are able to solve some of the impediments. I thank you, Honorable Speaker, for this opportunity, and I support the bill. I mean the report.
Thank you very much, Honorable Msamali, for kind words about about me, and I also, in the same vein, honorable members, just want to announce that Honorable Rosa Cole has been duly nominated by the chapter to replace Honorable Kasamba in the Committee of Accounts. and therefore from now she will be part of the membership of the committee of accounts. So, honorable members, I now want to call upon the chair of the committee on.
I don't know, Speaker. I was standing to catch your eye.
Oh, I had said those were the last ones, but you have something pressing which you want to.
Yes, right now, Speaker.
You want to contribute?
Just one
Okay,
point.
okay, honorable. Let me open it up. Yes.
Thank you very much, right now, Speaker. I equally support the motion. However, I would like to make sure that this House is mindful of what the duty available for the Council of Ministers. When you look at the act that we are seeking to amend, it was established in 2007. Of course, as a supplement, September 7, 2007, but the act is a 206 act. Right Honorable Speaker, for many years, from 2012 and some many more years, this act, implementation of this act failed here in the EAC for lack of a competition expert. That is one. I am touching on goodwill by the Council of Ministers to have these laws implemented. Number two, the amendment is being espoused and it is very good, but caught within the meaning of this act is the East African Court of Justice without the jurisdiction to handle trade-related matters. Right, Honorable Speaker, this is established as a palisade. It is a blockade, it is a bulwark that anyone would think that an act of this nature can be implemented where disputes arising out of this act, the act sends you to a court without powers to try. Therefore, the members of Summit ordered that the jurisdiction of the East African Court of Justice be extended to cover trade-related matters. A deadline was generated for August 2015. To date, the attorneys general have done nothing to sign documentation required for this extension to be realized. So, right honorable Speaker, as we support council over this, otherwise very good idea, I think goodwill now again needs to generally be generated by the council for East Africa to be a serious cooperation. I beg to support right honorable Speaker.
Thank you. Thank you. That was a very important observation. It would have been wrong to leave it out of the contributions, and I hope the chair of the council will say something about it. And now I want to call upon the chair of the committee to make his comments before finally I call upon the the chair of the Council of Ministers. Huh? Oh. Yeah, that's why I'm calling on the committee. I'm calling the chair of the committee to make his comment before I finally call the chair of the Council of Ministers.
Thank you, Mr. Speaker. My comment is simple. I just want to, first of all, appreciate all the members who contributed on this motion. If we look, the first member was talking about standard of all the laws within our community, which is very important because we cannot pass laws all the time, whereas in our partner state, their standards are still scattered. Also, they talk about the two partner states which are not yet having these competition authorities in their laws in their partner state. But, you know, the Republic of Uganda, it has a bill in the pipeline is coming. And the issue of South Sudan, you know, is a work in progress. They have, I think the council will have to speak to his counterpart to move forward with to catch other ESC members by introducing this body. So also I see the intervention of Honorable Francoise. She was worried about the references of those global international practice we were talking about in our report. This is a final report, by the way. Those are the Honorable Jean-Claude give a clear example of one of the block we have referred to. Also, I think also Honorable Fatma also did mention to strengthen the East Africa Competition Authority. This is very important because even like Honorable George said, the motion we have yesterday, we were talking about this illicit, how these multinational companies come, loot, and go, and leaving our countries with nothing. So this, I think, is the way to go, to put this authority, to empower it so that they can start dealing with this kind of competition which comes and sometimes these global competitor companies come here, they measure, then our small business suffers, as Honorable Gideon said, in the case of Kasolaga from South Africa, where it has been removed in the market. So now it's still craving for Kasolaga. So that's good. Also, very interesting, Honorable Mary Mugenya did mention two issues which we were talking about in our committee stage on how we should charge these companies. We charge according to their size and their industry. Of course, you cannot charge the major in agriculture sector and the mining companies. So there's a standard which the authority will use to charge them. And the small business, you know, if business is a business, they have to pay a share of their profit so that our community can grow. Also, I have to make a comment on what Honorable Bide just said, that we can have laws, we can empower our institutions, but when there is a problem, everything ends up in court. So since our court have no jurisdiction in trade matters, this is a major concern. So I think Chair Council is here, have understood. Then now the ball is in their hands to go there and to ask this Attorney General why they did not execute the directives from summit. Honorable Speaker, this is the main comment I can make. And also, I have to appreciate the council which brought this motion, this bill, so that we can just move fast and empower our institution to do good job, and so that our community can grow faster and better. I beg to read your right, Honorable Speaker. Thank you.
Thank you. Now, I want to call upon the chair of the Council of Ministers to reply.
Thank you very much, Honorable Speaker.
First of all, I want to thank the honorable members for the contribution they have made, which are pertinent. There are many issues that have been raised, Honorable Speaker, and I think as a council, we have a big role to play as another layer of this community. Of course, they must also accept that our failing starts by not even being present in EALA. This is a failure on the part of the council, because I was hoping to find my colleagues here filled in this, but I'm here alone. That's the first failing. That's the first wheel that we need to smash, because definitely communicate my colleagues that we need to be here to be with you, because this is our business. We are appointed to do this business. But I first want to colleagues to make sure that next time, whatever you do, we are present, respond together, and agree together. But a definite person, the observation I made, which are pertinent. Now, first of all, there is the issue of the two brother countries, Uganda and Southern Sudan. I think we definitely put this up with the council to make sure that they also set up the authorities and enact the laws, so that together we're in this business as a community. This competition is for all of us. Mergers can happen from Sudan, from Uganda to Rwanda, to many countries. So all of us should be knit together. So these are definitely the follow-up. The second issue that was raised that I want to take note of is implementation. I think, Honorable Speaker, I don't know if it's true for a problem in Africa, but in our region, we are good at speaking and less at implementing what we spoke and have agreed. But I think we need to overcome this, because there are consequences. And the consequences before on our people, not even us in this August Assembly, no. We are here for many people, for the many millions that we present. So if we don't implement, they are the losers. Of course, we also lose, but those that lose most are those that actually are meant to benefit from this business. Now, Honorable Speaker, I was of the feeling that when it comes to monitoring and implementation of this bill, we need to think of another structure, independent of the government bureaucracy, because we know how government works. If we give this implementation monitoring, this bill, to the same structure that are efficient, they are going to speak for businesses, which are beneficiaries of this. Because this bill is about private businesses, not about government. So the question is, who is going to police this bill? We need to think about this very seriously. We have been talking over the many laws that are not being implemented. It's actually not good for us and good for the community. But I think we need to think seriously where to house this bill, and I would urge my colleagues to see how best we implement this bill and others that concern our businesses in East Africa. Lastly, Mr. Speaker, there is the issue of consensus that has been the elephant in East Africa, as you know very well. I think when I was the chair, I'm now standing for my brother, Mr. Dani from Kenya. There are many issues that have been dogged by the issue of consensus. I'm asking one of my members that for this particular bill, the issue of consensus is out. It simply cannot work. We cannot have an order where every country is going to agree for us to merge two companies from Uganda and Rwanda, from Rwanda to Kenya. It simply won't work. So we don't have to have a bill that won't work. And you can see that happening very soon. So I beg to request that when it comes to the rules, after the bill has been acted and the laws have been passed, the regulation capture this issue of we have a quorum. With 6, how many must agree? Not everybody, because for me, everybody is academic. It does not work like that. You can't agree. Some of them want to be present in the first place. We are meant to be 6 here. So what made us not come will also make them not come for this very important business. So I think we need to take this into account. But for this authority, let's go for a quorum. 40, you can agree on This is not a political system or a process. No. We are talking of businesses that must move faster than as government. So I request that we think about the forum rather than consensus, which personally I don't believe in, honestly. Thank you, Mr. Speaker.
Thank you, Chair Council. I hope this issue of consensus, you as a council will take it up with the summit so that you can make some amendment to the treaty to remove it, because it is a hindrance to most of the implementation of most of the issues in the community. Now, honorable members, we go to the next stage, which is now to read this bill a second time. So, yes, I want to read. That's what I want to read. So now, honorable members, I now put the question that the East African Community Competition Amendment Bill 2020 be read a second time. And we'll vote now. Those who are for it, say ayes. And those who are against, say noes. Those who are against, say, so the ayes have it. Thank you. The ayes have it. And now we go to the next stage.
We proceed to the next stage, the bills committee stage, the East African Community Competition Amendment Bill 2020.
Now, committee stage. Yes. Committee stage, honorable members.
The bill is now in the committee of the whole house. The East African Community Constitution Bill 2020 is at the committee stage, and I will read out the bill, the clauses in successive order. We start with clause 1.
I propose that the question that I propose the question that clause 1 be part of the bill. Then I now put the question. The chairperson of the committee, you have something?
Clause 1 on page 2, we delete 2020 and insert 2021. Justification: to make a reference to the present year in which the bill is considered by the Assembly.
Honorable members, any comment? Honorable Chair, you have something? Do you agree? Okay. The chairman. Then it's okay, Honorable Chair. Can you just sit down? Okay. Now, honorable members, I put the question that clause 1 as amended be part of the bill. Those for say aye. Those against say no. The ayes have it.
We proceed clause 2.
Now, I propose the question that clause 2 be part of the bill. Chair, Chair Committee.
Clause 2, A on page 2 of the bill, delete paragraph A, justification. The definition of acquisition should be retained in the act to provide for those mergers that are intended through acquisition. B, clause 2 on page 3 of the bill, immediately after paragraph C, insert a new paragraph as follows. CA, by substituting the definition of competitor with the following new definition. Competitor means an undertaking that produces, distributes, or supplies substantially similar goods or services at the same stage of production or distribution of good or supply of service in the relation to another undertaking. Justification, to clearly provide a definition for the term competitor. The current definition of competitor does not provide any guidance and is not helpful in adequately identifying competitors. Clause C, clause 2 on page 3 of the bill, delete paragraph F, justification. The word mergers is not contained in the definition provided for in section 2, so there is nothing to amend. The phrase used in the section 2 of the act is merger, which should be returned to separately provide for acquisition and the mergers. D, clause 2 on page 3 of the bill, immediately after paragraph G, insert the following new paragraph. GA, by repeating the definition of price squeezing. Justification, the definition is redundant. The phrase was used in section 9(1)(b) of the Act, clause 7A of the bill, replaces section 9(1) by removing the reference to the term. E, clause 2 on page 4 of the bill, in the definition of predatory practice, delete the word or strategy of strategy of. Justification, it is unfair for the law to include instances whereby the action has not been implemented, strategies as predatory.
But the honorable members, any comment on that? If there isn't, honorable minister, any objection or any comment?
I concur with the amendments proposed.
Okay. Now, honorable members, I put the question that clause 2 as amended be part of the bill. Those for say aye. Those against say no. The ayes have it. Thank you.
Clause 3.
Clause 3.
Yes, Chair.
Clause 3, page 4. Delete the word by market participant. Justification. Part 8, Roman 8 of the Act provide for consumer welfare and the protection of consumers. Section 28 to 36 on consumer welfare provide for protection of consumers generally from false representation, dangerous and unsuitable good, and the liability for the defective good from any undertaking regardless of market. the word by market participant have the effect of restricting section 28 to 26, which is not the objective of part 8 of the act.
Honorable members, any comment? Chair, council?
I concur with the amendment.
Okay. Thank you. The chair, council, concurs. So, honorable members, and I put the question that clause 3 as amended be part of the bill. Those for say aye. Those against say no. The ayes have it.
Clause 4.
Clause 4, I propose the question that clause 4 be part of the bill. Chair.
Clause 4A, page 5 of the bill. Delete the word conclude and insert the word enter into. Justification. For clarity, the provision should be about the actual entering into of agreement rather than the negotiation or conclusion of agreement.
Honorable members, any honorable minister.
The amendment.
I now therefore put the question that clause 4 as amended be part of the bill. Those who are for say aye. Against say no. The ayes have it.
Clause 5.
Clause, I propose the question that that clause 5 be part of the bill. Chair, any? Okay. Honorable Minister, anything? Okay. I then put the question that clause 5 be part of the bill. Those for say aye. Those against say no. The ayes have it.
Clause 6.
I propose the question that clause 6 be part of the bill. Chair, nothing? Okay. So I now, members, anything? I now put the question that clause 6 be part of the bill.
Clarification, Honorable Chair.
Those
Which,
for
clarification. Which clause are we now?
6.
6.
We are in
I think
clause
there is
6.
an amendment on 6.
We are in clause 6.
Yes, there is an amendment.
There is an amendment.
Yes.
Honorable Chair, you said you didn't have an amendment?
Oh, I'm
No,
sorry,
there's no
it's-
amendment.
I'm
Yes.
sorry, it's me who
Okay.
but
So now, honorable members, I now put the question that clause 6 be part of the bill. Those who are for say aye. Against say no. The ayes have it.
7.
I propose the question that clause 7, not 5. Yes. Clause 7 be part of the bill. Clause, Honorable Chair. Yes, clause 7B, page 6 of the bill. Delete the word exclude and insert the word prevents. Justification. For clarity, competition may be prevented by, but cannot be excluded. Any member? A minister? Honorable Minister, thank you. I put the question that clause 7 as amended be part of the bill. Those who are for say aye. Against say no. The ayes have it.
Clause 8.
I propose the question that clause 8 be part of the bill. Honorable Chair, anything? No amendment. Honorable Minister? Okay. Now I put the question that clause 8.
Chair.
You have something?
Yes.
Okay.
A procedure matter. I think when you put the question and for record purpose, this is a bill which was sponsored by council, and the minister should be on, the council member should be on record. If he's conceding or is not, yeah.
Oh,
Yeah,
oh, he did say on
it's
record.
not on,
So
not on the mic.
minister,
So,
just put it on record.
yes.
That
I concede, I concur, Mr. Chair.
okay. Okay. So that was now clause 8. Huh? So I now put the question that clause 8 be part of the bill. Those who are for say aye. Those against say no. The ayes have it.
Clause 9.
I propose the question that clause 9 be part of the bill. Honorable Chair. Anything?
Clause 9, page 7, in the proposed section 12.2, delete the word competitive. Justification: to remove the limitation on the factor to be taken into account by the authority. Clause 9, page 8A, in the proposed section 12.2D, insert a new subparagraph 5, Roman 5, as follows. Roman 5, whether the measure fulfills an overriding public interest. Justification: to include the consideration of public interest in the criteria that should be taken into account by the authority before they determine whether a measure is anti-competitive. To centralize the consideration and approval of measures and remove the parallel process of the council approving certain measures. B, in the proposed section 12, immediately after subsection 2, insert a new subsection as follows. 2A.
Microphone. Microphone.
B, in the proposed section 12, immediately after subsection 2, insert a new subsection as follows. 2A, the council may make representation to the authority on any intended measures, specifying to the authority to overriding public interest that the measure fulfills for the community, which shall be taken into account by the authority when considering the intended measures. Justification: to provide for the council to provide information to the authority on measures which fulfill an overriding public interest and which may be beneficial to the community, although they may prima facie be anti-competitive. Page 8, in the proposed section 13.2, delete the word personal and insert the word undertaking. Justification: for consistency with the change from person to undertaking proposed by the bill. D, page 9, in the proposed section 13, delete subsection 4 and 5. Justification: consequential amendment, the matter provided for by this provision may have been incorporated in the proposed section 12.
Honorable members, any comment? Honorable Minister.
I concur with the amendment, Mr. Chair.
Thank you, Mr. Minister. I now put the question that clause 9 as amended be part of the bill. Those who are for say aye, against say no. The ayes have it.
10.
I propose the question that clause 10 be part of the bill.
No amendment.
Yes, Chair. No amendment. Honorable Minister.
I concur, Honorable Chair.
Yeah, thank you. Now, I put the question that clause 10 be part of the bill. Those who are for say aye. Those against say no. The ayes have it.
Clause 11.
I propose the question that clause 11 be part of the bill. Chair.
No amendment.
Honorable Minister.
I concur with the no amendment.
Thank you. Honorable members, I therefore now put the question that clause 11 be part of the bill. Those who are for say aye. Those against say no. The ayes have it.
Clause 12.
I propose the question that clause 12 be part of the bill. Chair.
No amendment.
Honorable Minister.
Concur, Honorable Chair.
Honorable members, I now put the question that clause 12 be part of the bill. Those for say aye. Those against say no. The ayes have it.
Clause 13.
13. I propose the question that clause 13 be part of the bill. Chair.
Clause 13 on page 10 of the bill. Insert a new paragraph substituting section 38, subsection 5 with the following new subsection. 5. A person shall be qualified for appointment to the authority as a commissioner if that person is the holder of advanced degree in the field of economics, business or trade, competition or law from a university recognized by the competent authority in the partner state and has at least 5 years experience in the relevant area. Justification: to open up the field of study from which persons can be identified to be commissioners of the authority. Competition is a fair and new area in the community that does not have many people with advanced degree, but persons with related qualification should be competent to serve as commissioners.
Yes, honorable members. As Honorable Nya.
Honorable Chair, I have two issues in this clause 13. If you read what has been reflected and from the comment of the committee, there is additional thing from apart what Honorable Chair of the committee has read. If you see in the report of the committee, this section 38 is what was talking, the committee was commenting on the commissioners, the tenure of 4 years, while we wanted a rationalization that commissioners in CASOA, in EHRC, in ESTECO, they are 3 years. So here, the changes has not been reflected as per the committee comment. That was one. But two, that in this amendment, it was talking about original act. It was talking about 3 commissioners. The amendment is stating that commissioners from partner states. At the moment, there are 6 partner states. So that means, according to the council amendment, it has to reflect according to number, the commissioners, according to number of partner states. But Mr. Chairman, we are making the laws here. We already we know that there are some other countries they need to join ESC. We have heard about DRC, we have heard about Somalia, we have heard about Comoro. So sooner or later, it will be 9 partner states. Now it was being amended because it was 3. Now it will be 6. When others are joining, it will be 9. So how many commissioners in this will be? So should it, if we leave as it is, we should not take care. Then it will be, I mean, we will have to bring another amendment after some other countries have joined. So I wanted my chair of the committee. This has been mentioned in our report, but it has not reflected in the changes. It came to the changes only on these qualifications. So that was my comment on this. I beg the council chair to, if you can rectify this.
Okay, thank you, Honorable Engineer Mnya. Honorable Engineer Mnya, this clause is talking about the qualification, the requirement for this commissioner to be part of a commission. Does not talk about the term of the commission. We're discussing about qualification, the requirement. So that's why you found that there is a certain qualification and experiences. So that point you're raising is about the term of the commissioner should be called the position. So I will seek the assistance of my clerk to give more clarification, because I don't even see where that terms of the commissioners being captured, although we discussed about it. But for this clause, we're talking about on the qualification for the commissioners, not the terms they should be in the office. That there are two things different. Thank you.
Information, Honorable Chair. Honorable Chair, I can catch your eye from here. Yes. Yes, Honorable Chair.
Okay. Yeah. You are on floor.
Yes, I think it is rare, or almost unheard of, for a law, not even an instrument thereof, to give details of qualifications. In my opinion, I think that may be reserved on the regulations to be adopted by the minister for implementation of an act, so that now we don't mention the qualifications in the substantive act itself.
Yes, Honorable Chair.
Can we seek a guidance from CTC?
Chairperson, I'll seek guidance to get the question, because my understanding is that the amendment that came to you is in respect of the principal act, the 2006 Competition Act was providing a number, 3 commissioners. It was, yes, I think it was 3 commissioners, because when it was made in 2006, there were only 3 countries at that time. Now, the amendment that came in respect of the commissioners is to open it up. That's why we have removed the number 3 commissioners. That has been deleted completely. So the intention is to open up so that when you get another country joining the community, you don't have to come back here and say, we need to amend to ensure that we have a commissioner from country A or country B that has joined the community. That was the intention. And I think that has been achieved.
Chair.
So I don't know what the Honorable Munya wants to clarification about.
I wanted to say that we have changed from the original, from 3 commissioners at the moment to 6 commissioners. We was not mentioning the number, but it was been according to the amendment. Commissioner, each partner state should appoint a commissioner. So that means I was saying that at the moment we'll be having 6 instead of 3. Absolutely. But I was talking in future. As I said, we are making laws here. In future, if we are, if the DRC is accommodated, Somalia and Comoro, that's 9. So how about the number of commissioners in this one? Will it not be too much or too many? Or after that time, then we'll have to repeal this and make another law. That was my issue. So I need a guidance from the CTC on this issue, or Council Chair.
Chairperson, as Can as you know very well, these are policy matters. At the moment, the policy direction that has been given, and we are not many countries anyway, is that each country should be represented by a commissioner, one commissioner, which is reasonable for the time being. I think when we get that situation
So
of
there's no limit to numbers, but the numbers are now just in accordance with the membership, which is 6. But in case there is additional members, they will have the same 1, 1, 1.
1, absolutely.
So there is no limit to members. It is only that it is now 6 because our membership is 6.
Yes. Chair, I would like to have a clarification.
Yeah.
Chair.
Who is? Okay, Kennedy. Kennedy, please.
Thank you, Chair. I seek your indulgence to have, I have 3 issues that I would want clarified. The first one was what was raised by Honorable Mbide on the qualifications, but this House will remember that on the statistics institution that the bill captured that. So I would want that our House is consistent in its legislative matters. The second issue is what our council member alluded to earlier on the issue of consensus. Now, this House is aware we have some institutions with such a heavy board that in fact work does not happen. So the clarification I would want is how do we ensure that even though we look out for the partner states, some of whom do not have these authorities, that we will not end up with a body that cannot function. So I submit, Chair.
You still had some?
Yes, I have.
Oh, okay.
This clause 13 amendment is concerning section 8, yes, 38. And here is mentioned 38.5. But in the report which our chair read here, we were commenting regarding the tenure. And is mentioned the tenure in section 38.3 that each commissioner shall serve for a term of 4 years and shall be eligible for appointment for further terms of 4 years. In our report, committee report, we were commenting that we should rationalize that there are some others, only the term is 3 years. Here is 4 years. Why is COSOA, ESTECO, EHRC is 3 years? Why we should not rationalize to make the same, either all 3 years or all 4 years? But in the amendment is not reflected, we've forgotten as a committee. It is reflected. Our report is recommending about that, but in their reflection of the bill, the change is not. So I wanted also this to be included. And it is in this committee report. But here we jumped on 38.5 about the education and the qualification.
But what was in the committee report is different from what is in the actual amendment.
Information,
in the bill.
Honorable Chair.
The body of this.
Information, Honorable Chair. Information.
Yeah, it is being captured.
Information, Honorable Chair.
In amendment by the committee. It is captured in the amendment by the committee. Union Clerk?
Yes, it's an information I wanted to give. Starting from what was raised, the point which was raised by Honorable Kennedy Musyoka about and also it was a concern by the Honorable Minister about the issue of consensus. I think these commissioners, the functioning of the board of this authority, it was not captured, it is not addressed in this act. It will be addressed in the regulations. So it is not part of this act. It was left out to be addressed in the regulations. Yes, and on the point raised by Honorable Engineer Munya about the term of these commissioners, and also referring to the report. In the report, we say that that there is a need to harmonize the term of board members of the institutions of EAC, because we have some who have 3 years, 4 years, 5 years, but for this particular institution, we agreed to maintain it as 4 years, because they are also, all those institutions, they don't even have 3 years. There are some which have even 4 years and 5 years. So we can't correct that issue through this single act. It will need just a decision by the council to agree on whether it will be 4 years for all institutions, or 3 years for all institutions, or 5 years for all institutions. So we cannot correct that issue through this single act. That was what we agreed in the committee. Thank you.
Thank you, Jean-Claude. I think what Honorable Munya was raising was an argument maybe in the committee, but finally the decision was that. I think that is what Honorable Cloud is
Clarification, Mr.
explaining.
Speaker. Clarification.
Honorable Mary wants to clarify.
Mr. Speaker, I think it would be helpful if you hear from the council member, the chair council, what the council view would be on that issue of harmonizing the term of office for all the authorities, institutions, or the board members in particular, commissions and so on. What is the view of the commission, of the council on that? I think what we have done as members of parliament, particularly the committee, we've given a position, a view. So I would like to hear from the council member.
Honorable Mary, I think we are discussing about this particular bill, what the committee agreed. This is what we want to confirm, that the committee wanted it to be harmonized, or the committee agreed that we leave it as it is, because not all the institutions, as Honorable Jean Cloud is explaining, if that is what was agreed in the committee, Honorable Chair, you can confirm, then we move on. But if there is because the question of whether the council wants to harmonize, that is another question which the chair council can answer separately. But let us solve the issue of this particular bill.
Further clarification. Further clarification.
I was insisting from our report. The report is here, is reading. There is a need for the council to rationalize and streamline the tenure for all the institutions of this community.
Yes. Now, Honorable Munya, from what I understand, that is part of the report. But did they make an amendment to say that now they should be uniform at 4 years? Was that recommended by the committee?
That is missing, Honorable Chair. That's why we forgot that we need to include.
It doesn't mean that was just a comment.
Information,
that there is a need. There is a need. The report expressed the need for the council to consider changing that policy so that they can rationalize them at once.
Information, Mr. Speaker.
Honorable Chair,
Information.
can you,
Chair.
instead of
Honorable Speaker and honorable members, I think there will be need to rationalize the term so that we don't have 3, 4, 5, and whatever. But let me put it this way: we should definitely rationalize it based on the wisdom you give us, honorable members. What's the best interest of these institutions? Number two, I think there could be some exceptions based on the function we expect from that institution. Be wrong with the exception, but ideally should have recognized terms. It's 5, it's 5. It's 4, it's 4. But exception should be allowed in case the institution serves a purpose longer than what the term you want us to have. That's happens. I think there's submission.
Yeah, thank you. Thank you.
Further clarification.
I think the chair has explained that issue.
Further
well.
clarification.
So why don't we, Honorable Munya, why don't we move?
Further clarification, Chair.
I think it was not that they had to do it immediately, but they will do it, rationalization. But as the chair says, there will be exemptions to that rule. But as for now, the bill we are passing, you have that term of 4 years, which was is what was agreed. I think that is my understanding. So can we move? Now, I therefore want to put the question
Right now,
that clause 13.
We didn't get an answer on. I don't know, Chair. There was a clarification sought on the qualifications that have been put in the substantive act. Right now, Chair, competition is a revolving matter. What has been legislated here, the qualifications are even vague, right, Honorable Chair, to the extent that one must have an advanced degree in the field of economics, business or trade. Now, which degree is this in business or trade? It is not given details in terms of business administration, trade-related matters. Right, Honorable Chair, these are all usually left a statutory instrument that is usually enacted, that governs by council, that governs the implementation of an act, because it is revolving. Advocates all over East Africa right now are now going for further studies in oil and gas. We have been doing these studies with the Chief Justice, you can imagine. Why? Because now the economies in Africa have started, of course, management of legal affairs of oil and gas. It keeps changing, and we don't need to come back here when it changes.
I think the question which you put to the CTC was whether detailed qualification should be included in a bill
act,
or it should be left to the regulation.
Yes.
If you are not satisfied with the answer he gave, I think the CTC
he hasn't yet addressed it.
Can you answer? Specifically, Honorable Mbide was raising the question as to whether a detailed qualification description should be given in the act, the main act, or it should be left to regulation. I think that was the basic question which you, yes. Can we have that one, the CTC?
Thank you, Chairperson. Chairperson, as you know, we have challenges of listing all the qualifications that are required for membership to the competition authority. And I think that is why they have given general areas of trade, law, and I think business related. Because the danger we are going to have is if you start listing, there are chances that you are going to leave out a number of qualifications that may be relevant to matters of competition. So my suggestion, Honorable Mbide, is that we leave it as it is, and then when we get opportunity, we'll expand. But we don't saddle the bill with a lot of qualifications which may not be exhaustive.
Chair, you are not
Chair, that's not a suggestion by the committee, not the bill. So it was a committee. Right, Honorable Chair, this was a committee suggestion, not a suggestion in the bill proposed by council. So which one do we leave as it is?
Information, Honorable Chair. Information.
Yes.
I just wanted to inform Honorable. Yes, the concern he's raising is very important, but the information which I want to give is that this amendment by the committee, it was amendment to the clause which existed already in the bill. We wanted it to extend the qualifications of someone who can be a registrar of this authority. It was already there, but wanted it to export. The amendment by the committee is to extend
To expand.
To expand the field. Yeah, the scope. But the concern of his is about whether this qualification should be in the main act or should come in the regulation. But also it was I remember the point made by Honorable Kennedy that the precedence here in this assembly is that we have been doing the same even for the previous acts we have passed. I remember for the Statistics Bureau bill, even the monetary union, monetary institute, we have done the same. We have put qualifications in the main act. So I don't think we need to change it now. But if members agree, maybe we can do as he's proposing.
Yes.
The information was that it was already in the main act.
Yeah. Okay. Yeah. In fact, I've seen many bills here past year where qualifications are included, but maybe Honorable Mbide is telling us that that is not the right thing to do. But the CTC, can you just clarify? Were you saying we leave it as the originally was, where qualification was also given, but to a limited area, and the committee only expanded it to include more qualification, or we leave it as suggested or recommended by the committee, that they expand on what was already originally there.
Chairperson, what I was saying is that we go with what the committee has suggested, but don't go into the details of listing.
Yeah, okay. Okay, I think it is clear. Huh? Further information? Honorable members.
Yes, just on this, because we are mentioning a previous act we passed. I remember I was part of the team that dealt with Monetary Union Act, whereby, as far as this issue is concerned, we just use the terminology fit and proper. The person should be fit and proper, and explanation was given under definition. We submit.
Oh. So, honorable members, I think we have exhausted this. I want to now put the question.
Further clarification, Honorable Chair.
Honorable members.
Yes.
Okay.
Okay. Thank you. Chair, thank you for this opportunity. We shouldn't get tired, Honorable Chair, because we are making the law and we may be blamed at the end of the day.
Okay.
Because we hurried.
No, we are not in a hurry.
Yes, thank you. It is on the same, since we have now agreed that we leave it as the committee has recommended. So I wanted to make further, propose further amendment here. That since we have allowed to include the fields, I see we seem to be limiting ourselves again. For example, let me read. They're saying a person shall be qualified for appointment to the authority as a commissioner if that person is a holder of an advanced degree in the field of economics, business, or trade, competition, or law from a university recognized. So we stop there. And from the guidance of the CTC, we are again limiting ourselves. So my view is that we would say a person, if he is a holder of advanced degree in the field of economics, business, comma, trade, comma, competition, comma, law, or any other relevant field from a recognized university. So we are saying any other related field. Yeah, thank you.
Acceptable, Honorable Speaker.
Yes. I now put the question that clause 13 as amended be part of the bill. Those who are for say aye. Those who are against say no. The ayes have it.
Clause 14.
As I propose the question that clause 14 be part of the bill.
Clause 14, page 11. A, delete proposed subsection 3A and insert the following. 3A, the registrar shall A, be the chief executive officer and accounting officer of the authority. B, be the secretary to the authority. C, subject to the direction of the authority, be responsible for the day-to-day management of the affairs of the authority. D, carry out such other functions as are conferred on him or her under this act or as directed by the authority. Justification: to specify the roles of the registrar. B, insert a new paragraph in clause 14 of the bill, substituting subsection 4 with the following. 4. A person shall be qualified for appointment as a registrar if that person is a holder of an advanced degree in the field of economics, business or trade, competition or law from a university recognized by a component authority in the partner state and has at least 5 years experience in the relevant area. Justification: to open up the field of study from which person can be recruited from appointment as a registrar. Competition is a fair new area in the community that does not have many people with advanced degree, but person with related qualification should be competent to serve as a registrar.
Honorable members, any comment? Yes. Honorable Minister? Okay, I'm sorry.
Thank you. This is still the new clause, the new sub clause we are subsection which we are inserting, that is subsection 4. That's about the qualifications again. So my view is that we amend, we include a or any other related field, just like we had done with the previous one. Such that subsection 4 reads, a person shall be qualified for appointment as a registrar if that person is a holder of an advanced degree in the field of economics, business or trade, competition or law, or any other related field from a university recognized. Then we proceed, Honorable Chair. If I'm supported by Chair Council and the Chair, thank you.
Honorable Chair.
Concur.
Yes. Okay. Thanks. Oh, Honorable Fatima, you have.
Thank you, Honorable Chair. These drafters of this bill looks like they are biased against other professions. Honorable Chair, if you look at the clause we've just disposed, 13, they say advanced degree in the field of economics, business, trade, competition or law. Again, now they say the same thing. Honorable Speaker, I think this is unfair to other professions, and this should be made.
Honorable Fatima, that has just been treated by Honorable Musamali. He says, or any other qualification, relevant qualification, and the
Even
Chair
in this one?
Council has already
For this also?
accepted it, yes.
Oh, also. But Chair, I think they are biased in this thing, whoever is drafting.
Okay. Yeah.
They should include people with agriculture. Competition is not about law or anything.
Sorry, Honorable Fatima, for
or environment or all those things.
Engineering.
for annoying you, but it has been treated. Yeah. Now, Honorable Minister, any other comment?
I think on this, Honorable Speaker, these are relevant to this area that we're looking at. We're talking
Okay.
about.
Okay.
So if you bring others that we don't understand this, it may be a problem.
Okay.
I submit.
Thank you. Thank you, Honorable Minister. So I now want to put the question that clause 14 as amended be part of the bill. Those for say aye, against say no. Nah.
Clause 15.
I propose the question that clause 15 be part of the bill. Yeah.
Clause 15, page 11 of the bill. Delete paragraph B and insert the following. B, by substituting for subsection 3 the following 3. The council shall, on the recommendation of the authority by regulations, prescribe fees for filing and other activities required by this act or regulation made under the act. Justification: to anchor in the act the fees prescribed by the authority for filing and other activity concluded by the authority.
Members, any comment? Honorable Minister. Yes. Now, members, I therefore now want to put the question that clause 15 as amended be part of the bill. Those for say aye. Those against say no. The ayes have it. So
Clause 16.
I propose the question that clause 16 be part of the bill. Yeah.
Clause 16 on page 11 of the bill. Immediately after the word turnover, insert the following word. Insert the following word within the community. Justification: to specify that turnover referred to is the turnover of the undertaking within the community and not the global turnover of the undertaking.
Yes. Honorable members, any? Honorable Minister, any comment?
I concur, Honorable.
Thank you. I put the question, therefore, that clause 16 as amended be part of the bill. Those for say aye. Aye. Those against say no. The ayes have it.
Clause 17.
I propose the question that clause 17 be part of the bill.
No amendment.
Amendment. Minister.
I concur, Mr. Speaker.
Okay. Now I put the question that clause 17, but there's no amendment, as be part of the bill. Those for say aye. Aye. Those against say no. The ayes have it.
Insertion of new clauses.
Now, new clause 18. I want to call upon the chair to introduce to move a motion that a new clause 18 be read for the first time.
Thank you, Honorable Speaker. I beg to move a motion of insertion of new clause.
The new clause is replacement of section 46 of the Principal Act.
I want to put the question that the new clause. Oh. Huh? Yes, first of all, I want to call upon the chair to justify the introduction of this new clause. Chair?
The justification of this new clause, section 46, is supposed to provide an avenue for the court to review the decision and action of the authority, but is not clear on whether it is through an appeal or reference to the court. Appeal is a creature of status and should clearly be provided for the law. Replacement of section 47 of the Principal Act. Section 47. Okay.
Yes, honorable members, I would like to ask whether you agree that we amend this clause. I mean that we amend the proposed new clause number 18 after the justification by the chair. Now, if no, just see. Now, if there's
Chair.
no, yes.
I had a
Honorable
concern
Fatima?
on this new 47.
Huh?
The 47. The one requirement for reporting. Just wanted to understand why the committee felt that they should specify the reporting to 6 months instead of saying end of the financial year. Chair, what I'm saying on the replacement of section 47 of the Principal Act about reporting is, I don't know whether they want to replace section 47 of Principal Act and remove it, or they are inserting in this, and I wanted to know why they are saying that's within 6 months instead of saying immediately after the financial year has ended. Chair, I wanted to know whether they are removing or
Information?
But Honorable Fatima, we are not yet there. You are far ahead of where we were. We are still on new clause 18. So we are coming to that one for Honorable Fatima. Now, honorable members, if you are satisfied with the explanation given by the chair for introducing this new clause, I want to put the question that the proposed new clause be added to the bill. Those in favor say aye.
specific. Which clause?
Say no, ayes have it.
Chair, you have to be specific. No, you have to mention it
New
specifically. Clause 46.
New clause 19.
Is it 19?
Is it 19?
Yes. Now, Chair of the Committee of Communication, Trade and Investment to move the motion that clause 19 be read the first time.
Honourable members, it seems some members didn't know what you are talking about here. The insertion which you just passed now, which is the replacement of section 46, it become amendment 18. So now this one, it will be 19. And the replacement of section 47 of the Principal Act, section 47 of the Principal Act is substituted with the following. 47, reporting. 1. Honourable member, I move a motion that new clause 19 be part of the bill.
The new clause replacement of section 47 of the Principal Act.
Yeah. Now, can I put the question? Yes, that the new clause be read
Clarification.
for the second time.
Okay.
This new clause now be read for the second time. Those for say aye. Those against say no.
Procedure.
Say those against say no. So the ayes have it. You know, you are calling for procedure when we are voting.
No, it's okay.
You know, you can't call for procedure during voting. You have to wait until the voting is over, then you call for procedure. Yes.
Preamble.
Honorable Chair.
Yes. Yes, Honorable Rose.
Thank you, Honorable Chair. No, I think I'm getting a bit confused the way we're moving here. But when you say that the new clause be read for the second time, and you are now moving to the next, I see the clerk now moving to the next. I was waiting to hear you say the new clause as proposed, and of course also the justification, because I had issues here in this clause to do with that is the 47 on reporting. There are some statutory reporting requirements for any authority or institution. And one of those statutory requirements is financial statements. You should be made clear here, because when you talk about annual reports, what are annual reports? For financial statements, for the financial year, for financial statements, it is normally very clear. You have to state it there in the instrument. So I was waiting to move it as an amendment here, Honorable Chair. But if the thinking that it is not necessary or it is detailed, then we can skip it. But I think it is a substantial issue that should be put here, because for any authority, you are required to prepare financial statements. So when you classify everything here as a reports, this is a requirement, a statutory requirement. Thank you, Chair.
Yeah, Honorable Rose, I was just about to interrupt you, just to ask you, because this is now the second time, the second reading, where now the chair is supposed to justify and you can make your contributions at this stage, when we are now reading this for the second time. The one which we went through was called first reading, which is normally just
procedure, Mr. Speaker.
Which is procedural. So now this is the stage at which you can raise the issues. And Honorable Chair, is now your time to explain so that members can understand.
Procedure, Mr. Speaker.
Yes, okay. Okay, Honorable Makame.
Mr. Speaker, I'm rising on point of procedure, and I'd like to move a motion on Rule 30 to suspend any of the House rules, and I'm rising to suspend Rule 11 so that we complete this item which we are currently dealing with. Mr. Speaker, I beg to move.
Yes, seconder? Okay, he's seconded. Yeah, okay, thank you. I've seen it is seconded by many. So I want to put the question that we suspend. We suspend Rule 30. No, is it? No, we suspend Rule 11 to continue with the business of the House until the item on the table is concluded. Those for say aye. Those against say no. The ayes have it. Now the chairperson, can you proceed?
The placement of Section 47 of the Principal Act. Section 47 of the Principal Act is substituted with the following. 47, reporting. 1, the authority shall not later than 6 months after the end of each financial year prepare and submit to the Council an annual report in respect of the financial year containing the report on the operations of the authority and any other information the Council may deem appropriate. 2, the Council shall cause the annual report on the authority to be laid before the East Africa Legislative Assembly for the consideration of the Assembly. 3, the authority may prepare and publish reports on matters within the mandate of the authority. 4, the authority shall send copies of any report published under this section of the competition authorities of the partner states. Justification: to reconcile and harmonize Section 47 within the procedure on reporting for institution of the community in order for Assembly to be able to consider the report from the authority in accordance within Article 49, Sub-Article 2C of the treaty. 2, to require the authority to provide report published by the authority to the competition authorities of the partner state, since according to the Section 43 of the Act, they are also involved in the implementation of the Act.
Honorable members, I want to ask if you want to amend the proposed new clause as explained by the chair of the committee. If there is any, is there any? Yes, Honorable Fatima.
Thank you, Honorable Chair. Honorable Chair, I was really concerned. I think reporting is very crucial, both financial reporting and other reports. It can be a research, it can be other activity-based report. But Honorable Chair, I had 2 concerns. One, the authority, the committee is putting a time frame on the reporting. And it says the authority shall not less than 6 months after the end of financial year prepare and submit. Honorable Chairman, I think the best thing is to say the authority shall submit a report at the end of every financial year, not giving them 6 months, or I think if they're given 6 months, they will even come back after the end of that year. So I think it's immediately end of every financial year. I don't know whether it's not a good practice where they write 6 months. And I don't know what informed their decision to specify the time frame of the report. Honorable Chair, the council caused the annual report to the East Africa Legislative Assembly. I thought, Chair, any report that is done by organ of EAC is an automatic to be subjected to the East Africa Legislative Assembly. I don't know what is the reason why they are putting specifically that the council submits the report to the Assembly. I think I wanted to understand it. Chair, number 3 says the authority may prepare and publish report on matters within the mandate of the authority. And that is it's not clear in the bill, or why is it being, because this is an automatic thing that usually is captured in the functions of any institution, that they can do any other activity and prepare reports on that. Chair, I wanted to understand the rationale behind it. And 4, it also says the authority shall send copies of any reports published. I think it should say the authority shall send copies of all reports published under this section to the competition authorities of the partner states. All reports, instead of saying any. Thank you, Honorable Chair.
Further clarification?
Honorable Umukiza.
Yeah, thank you, Honorable Chair, for the floor. I support the inclusion of these two clauses. The procedural matter I was just raising, when he told me that they were just passed, I was wondering if those new clauses, because they were added after they have considered this, because they received this after the first reading, and those two were not part of this previous bill. So I was considering this new as at the first reading stage, because they were not included in the previous bill they received when it was referred to the committee for scrutiny and consideration. So that's why I was saying a procedural matter of calling this first reading for those two. And also, as I support under 7, now I'm reading 47 that has been, was 19, I think. The council shall cause the annual report of the authority to be laid before the East African Legislative Assembly for the consideration of the Assembly. Normally what we do, under Article 49 of the treaty, functions of the Assembly. 2, then where we consider the reports, the Assembly shall consider annual reports on the activities of the community, annual audit report, etc. And the activities we consider through the purpose committee are the activities compiled by the Secretariat. So they bring all activities under the report. I don't know if we will be considering this separately as a special treatment for only this institution, and the others are still under the Secretariat, consideration, because they will receive them from the Secretariat as a compiled report. It was just a clarification I'm seeking, as I also wonder if we pass these two new clauses as second reading, since it's the first time we read them. Thank you. I submit.
Okay. Yeah, thank you. Thank you, Honorable Mukiza. So you are talking about the first, this is a clause number rule number 70, procedure in committee of the whole house, number 16. If you look at number 16, it says that upon the title of any new clause being read by the clerk, the clause shall be deemed to have been read the first time. So now we are now in the second reading where we are now discussing. So that's what the rules of procedure say. So, Honorable Chair, there
Further
was
clarification.
Huh?
Further clarification.
Honorable Rose wants to. No, yeah, Honorable Rose, this is now the time for you to raise what you.
Yeah, thank you, Honorable Chair.
Yeah.
I'm also seeking clarification from the chair, and of course, any member of the committee with regard to the kind of reports we are meant to receive from the authority. And this one is to do with the statutory requirement for any authority that is established by this community or organ. Now, Honorable Chair, and I think I have the Act supplement here, where one of the sections says the authority shall be funded from the budget of the community. So that implies, just like any other institution formed by this community, it will have to prepare financial statements. And financial statements are a statutory requirement. And therefore, in my thinking, for statutory requirements, we have to explicitly put it here as a report. A report, not just any report. It cannot be, yeah, it could be an operational report, but because it's a statutory requirement, it has to be clearly defined here that as one of the reports should be financial statements. So I wanted to know, unless it is explicitly put in any other section or clause in the bill or in the law. In 47 here in reporting, where I believe this one should be, I therefore want to propose to the chair that he amends that 47.1, the new section that is introducing, to read that the authority shall not later than 6 months after the end of each financial year prepare and submit to the council an annual report in respect of the financial year containing the annual financial statements, the report on the operations of the authority, and any other information the council may deem appropriate. That is the amendment I wanted to be introduced, unless there is anything contrary, which implies that this particular amendment I'm bringing is explicitly pronounced anywhere else in the bill. Honorable Chair, that's the amendment and to move.
So you are suggesting that it should be number 5?
Chair, it can be a standalone amendment.
You want number 3 to be amended?
47.1, that reporting, the justification.
47, yes.
A replacement of section 47. That's now the new section 19 rather, on reporting. That it should be explicitly stated there. One of the reporting requirements are the annual accounts, and that's the financial statements.
Yeah.
On an annual basis.
Yeah,
Honorable Chair, thank you.
The reporting here is listed as number 1, number 2, number 3, number 4. And are you amending any of these, or you are introducing she's amending number 1 to include the explicit reporting on the financial status of the authority.
To produce financial statements as one of the reports that they have to provide to council.
Okay.
Yes. It should be stated there, financial statements as well.
Information, Honorable Chair.
Honorable Chair, what do you say to that? You concur? Honorable
Information.
Chair,
I concur with you.
Information.
You also concur. So
Information, Honorable Chair.
the name of Honorable Rose is taken care of. Is accepted, Honorable Rose. So, John Claude, you have another one.
No, it's just an information to,
Huh? Just information, okay.
To give the background of how we
Okay.
arrived on this. But maybe I don't know if procedurally I'm right, because already the chair has pronounced himself and the council
Okay.
member.
Okay.
But if you allow me, Honorable Chair, what I wanted to say is that normally, as Honorable Rose has put it, she's right that financial statements are treaty matters, and all institutions and organs of the community has to produce them annually. And normally, we receive those financial statements of institutions and organs together. They are brought together in the same document by the council chair, or the council chair. So we don't treat separately institutions, financial statements of institutions, each and every one, each and every institutions and organs of the community. We treat the financial statements together as one document. So we didn't want to put it here because we just wanted this report on operations and the other financial statements of organs and institutions will come together as it is usually done by the council chair.
Okay.
So we didn't want to put it here. That is the reason. But if members agree with the proposal by Honorable Accord, it will be also right, but it will be double work because we will treat it here in the house. And again, it comes back as in one report produced by council chair.
No, not us. It goes to the council, and the council will bring it here.
Yes, but it will be double work to us as the assembly, because we will have done it or treated it separately, singled out as it is stated here. It will be stated here in the act, and also comes back in a single document as it is usually produced by the council.
No, it will not come to us. It will go to the council.
Yeah, but what I'm saying is yes, of course, it passes through the
Can I
council
clarify
ministers, and
to
the
you?
council ministers is the one to bring it to the assembly. But
Okay.
it will be double work. If we mention it here in this act,
Okay.
it will be double
Can I
work.
clarify?
Okay.
Yeah.
Okay,
Yeah,
thank
can
you.
I clarify?
Thank you, Honorable Jennifer. So if that is
Clarification,
accepted,
Chair. Can I clarify to him?
huh?
I would like to
If
clarify.
that is
Perhaps
accepted,
give information to Honorable Jean Claude.
I'm not seeing.
It's me.
Oh, Honorable Rose, okay.
Yeah, I'm the one who raised it. Yeah, why I'm raising it, what Honorable Jean Claude is saying, his thinking is that it's double work. No. All these institutions prepare these statements and present to council. So the document you see council lay there has all these documents. Because where else do they take this document apart from council? There is nowhere else in the law here, which we have, where they are required to take these documents. So I'm only being specific that including financial statements, they should prepare. And when they prepare those statements, they should hand them over to the right authority, which will bring them here to Parliament as one of the documents to be laid there and to be audited, just like we audit all the institutions of this community, which receive the public funds. So basically, that is the clarification I wanted to give to
Honorable Rose, I think Jean Claude had accepted when the chair had already spoken, and so he was just talking. I mean, we gave him, but he had accepted what was there. So please let us not spend more time on this. That one has been accepted. So let us now move further. Is there, clerk, is there any other new? Huh? So now I want to just put the question that the proposed new clause number 19 be added to the bill with the amendment. Those for say aye. Aye. Those against say no. The ayes have it.
We proceed to the preamble.
Now,
Chair,
now,
Chair, before you proceed to the preamble.
yes, Honorable Rose.
Yeah, Honorable Chair, I see in the bill and the amendments, there's a requirement for, actually there's a recourse to the other subsidiary law. And that is the law, the subsidiary law that operationalizes this what? This bill, and that is the procedure. Is it procedures or rules? Something. I saw it, I wrote it here. Page 5. Yeah, with reference to the subsidiary law that is required here to prepare regulations. I just want to be satisfied that within this law, we have given the time frame for preparation of the regulations to operationalize this law. If it is not there, then Honorable Chair, before you go to the preamble, there is a need to insert another clause that will give a time frame within which the authority should prepare the regulations. Otherwise, it may be difficult for this law to be operationalized when we don't give any time frame for the preparation of regulations to operationalize the law. I know the act is already there, but I just want to be comforted by the chair that in the perusal of the bill, actually there's a time frame within which the regulations should be prepared, or else it will be very difficult for this act to be operationalized. And if there's specifically any delay, and some people may want that delay to occur because they know what they want to achieve. So I think we have to make strict adherence here by giving a time frame within which regulations should be prepared. Honorable Chair, thank you.
Thank you, Honorable Rose. CTC, I think that is an issue which is important because it is the regulations which will operationalize the bill when it becomes an act.
Yes, Chairperson, I know regulations are provided for under Section 49, but preparing regulations is a function of the council, as it is stated there. And I would suggest you give the council time to make those regulations, because my fear is that once you put a timeline of 3 months to make the regulations, it may not be feasible. You know, even for the competition authority there are certain things that need to be put in place and all that. So I wouldn't want you to legislate something that may not be possible to achieve practically.
Information.
Information to who? There's nobody on the floor. Information is normally given to somebody contributing. Me, I don't want the information. Honorable Chair, the CTC says that making these regulations is the responsibility of the council. So what is your take? Members are concerned that when it is left open-ended, sometimes it takes forever to operationalize the bill or the act when it is passed. And members would like to know some indication. What is the CTC is concerned that we should not put it in the act because it might not be implemented or it might not be practicable. But can you just maybe say some indication?
Thank you, Honorable Speaker. I think CTC is right, but again, we cannot work in an open-ended system. Again, that's not good for the council. I think we need to agree internally that we have to set some time limits. It could be 4 months, maybe 5 months, but at least also have to have time limits to avoid having open time situation. Right? Thank you.
Clarification.
Honorable Rose, what was your
clarification?
Your idea about the the time limit, what were you suggesting?
Honorable Chair, you see, as perhaps just to take into consideration what the CTC says, but you know, once this bill comes into force, and that's when all the member states have signed it into law, and the council definitely now puts in force the authority, or even before the authority is put in place, the council will have to prepare the subsidiary legislation. It will be required that they prepare also the subsidiary legislation. So if it is the duty of council, maybe within a year, because there will be so many things happening, at least a year. After the bill comes into force. Comes into force by fact that it has been signed into law by
information
by all the member states. Then within 1 year, the council, if that is the duty of council, should be able to prepare the what? The regulations to operationalize the law.
You accept information from Gideon?
Accepted.
Or you have finished?
Accepted, Chair.
Okay.
Thank you, Honorable Chair. I've been looking for these words so that and also to get somebody to inform Honorable Member Rose now has accepted. Honorable Chair, at the time when we were deliberating on this bill, this information, this concern came about the limits, the timeline for the development or the development of the regulations. So the challenges that were expressed include: one is that after the bill has come into force, the authority itself has to now, the board has to develop the regulations. And then when they develop these regulations, it is now one level. They have now to send it to the council. When it reaches the council, it takes another procedure from the council, which is apart from what has been done by the authority. So these are two levels. So these two levels, it was ambiguous to determine, to give it one timeline, to say it must be done at this time. So we found it hard to determine a time for the authority to finish and then give time for the council to take its process until now they complete the regulations. So what we thought was the expression by the council, by the CTC, that we leave it to the council. Of course, the authority is the body that needed to be done urgently. When they do their work, now the council has to take the responsibility. Thank you.
Thank you, Honorable Gideon, for the information. Honorable Rose, Honorable Rose, what I wanted to suggest to you is that if you feel very strongly that you must put timeline, then we shall use Rule 70(4), which says that any proposed amendments for which notice has not been given shall be handed to the chairperson in writing. So if you feel you should have it, then prepare it, write it, and give it to me in writing. Then it will be incorporated. Yes.
Chair, we are considering the bill, and we are going to pass it today. So if you want me to give it to you in writing, how do you want me to do it?
Writing this takes you about 2 minutes.
I'm writing another one. I'm still writing another one, which I've just proposed.
So if you don't want to write it, then how is it going to be incorporated?
Honorable Chair, I'm writing this one. But if it is the view of this House that this amendment is not necessary, it's just okay, because we are making the law. I'm writing down. Okay. But I will not specify which clause it will be. Okay. It will be the drafters or the legal fraternity here who are responsible for this bill to put it together. But I'll draft it. Yes, but again, I just wanted to say that perhaps the chair council here can propose to us a time frame within which the council thinks is comfortable, because as the Honorable Gideon has put it, that maybe it takes time, maybe 1 year or 2 years or 3 years. Yeah, but we need to put a time frame for that.
He had suggested 4 months.
No, 4 months, I think, is
4 or
when you
5
look
months.
into what the Honorable Gideon said, it may be too small. Even to me, it can't be 4 months. Because the authority has to, first of all, take effect. You know, after, once the law is passed, the process of establishing that authority, the recruitment process here, you can see they are suffering here. 2 years down the road, we don't yet have clerks and all that. It's because of those things Gideon is talking about. So taking into account those challenges, sometimes, you know, operational issues here, then maybe we leave it to the liberty of the council to give us a time frame, but we need to give a time frame here. Honorable Chair.
Okay.
So once council gives us a time frame within which they are comfortable, then I draft the amendment. Thank you, Honorable Chair.
Okay, thank you. Thank you, Honorable Rose, for now giving us a way forward. And honorable members, I now want to put the question that the proposed new clause 19 as amended be added to the bill. Those for say aye. Those against say no. The ayes have it. Now,
preamble.
Now preamble. I put the question that the preamble be part of the bill. Those who are for say aye.
Aye.
Those who are against say no. The ayes have it.
The title.
I put the question that the title be part of the bill. Those for say aye.
Aye.
Those against say no. The ayes have it.
We proceed to the next item. Motion for the House to resume.
Now, I want to call upon the chairperson of the Council of Ministers to move a motion for the House to resume.
Honorable Speaker, I beg to move that the House be resumed and the committee of the House, the whole House report thereto.
Honorable members, I put the question that the House do resume and the committee of the whole House reports thereto. Those for say aye.
Aye.
Those against say no.
No.
The ayes have it. So, the honorable members.
Report from the committee of the whole House.
Honorable Speaker, I beg to report that the committee of the whole House considered the bill entitled the East African Community Competition Amendment Bill 2020 and passed it with some amendments. I submit, Honorable Speaker.
Adoption of reports from the committee of the whole House.
Honorable Speaker, I beg to move that the report of the committee of the whole House be adopted.
Now, honorable members, I now put the question that the report of the committee of the whole house be adopted. Those for say aye. Those against say no. The ayes have it.
Okay, we proceed. Item 5 on the order paper, the East African Community Competition Amendment Bill 2020, third reading by way of motion.
Honorable Chairperson of the Council of Ministers, move the motion.
Honorable Speaker, I beg to move that the East African Community Competition Amendment Bill 2020 be read for the third time and do pass.
Honorable members, I propose the question that the East African Community Competition Amendment Bill 2020 be read at that time. Honorable members, I now put the question that the East African Community Competition Amendment Bill 2020 be read at that time. Those for say yeah, aye. Those against say no. The ayes have it.
An act of the community to amend East African Community Competition Act 2006 to streamline the provisions on mergers with international practice on competition, to confer legal personality on the authority, to empower the authority to impose and collect financial penalties and provide for related matters.
Yeah. Honorable members. Huh? What? Yeah. Now, honorable members, I just wish to congratulate you for a very good job. You have worked very hard throughout the afternoon, and I want to appreciate. Huh? Yes, and I want now to ask the clerk to read the long title of the bill. You have already read it? Okay. Then, honorable members, I have congratulated you for a very hard job, and I want to now finish by declaring that the East African Competition Amendment Bill 2020 has been duly passed by this Assembly. And I congratulate the mover, the minister. I congratulate the honorable chair of the committee and all the members of the committee for a job well done. Thank you very much. Thanks. Now, honorable members, now it is time for us to adjourn the House, and the House stands adjourned until 2:30 tomorrow, Thursday, in the afternoon. Thank you, honorable members.
Chair of the committee. Chair of the committee.